Okay, I think I'm live here. Let me see. Why isn't it showing me a slide? It says I'm live. Can you guys see me? Hear me? Here we go. Okay. Wow. It took forever for YouTube to apply it. Yeah, so my I don't have my filter anymore. My Snapcam stopped working on my camera. Snapcam was a program that they shut down their servers in 2023, but GitHub had a patch on it for iMac for the past 2 years. For some reason, though, it just stopped working, but I'm not the only one having problems with it. There's like already tickets and shit being pulled for it. So hopefully they fix it soon because I don't like this. I almost want to turn the camera off, but I'm not gonna because I'm not a pussy. So anyway, hi. Hi, Sunny D. Hi, Robin. Hi, Koi. How are ya? Okay, so there's been some interesting filings lately. With the Katie Joy and 7M lawsuit. Now, Southern Mutton did a video where she went over 7M's motion filing, whatever it is they file. You know, let me try and use actual words here to describe shit. But she read the, what was it, 917? The notice of motion and motion party plaintiff. Okay. The memorandum, the proposed order document, then the affidavit of attorney, the exhibit list, the affidavit of the plaintiffs. She read everything except for the memorandum from Katie Joy's side. So I thought we could read that to see Katie Joy's reaction to their motion for, what did they ask for again? I think it was a summary judgment? I know it, and I know that they did file for a temporary injunctive and for a temporary injunction. That's one thing that they did file for against Katie. In other words, they're asking the court to compel Katie to shut her mouth, basically stop talking about the plaintiffs, you know, whatever. Let's not make this worse while we're fighting about how bad it already got, you know. But in addition to that, I thought that they filed for something else, but maybe not. Let's see, proposed order document. Oh, and my computer is running so much faster now. I've been getting ready for court, and my computer was just I had no structure, no organization, nothing on it. So I went through, I spent probably 3 whole days just cleaning shit out, putting shit together. And it's just so much. We're talking like 7,000 files got deleted. I just say her watching as I emptied the trash bin, I'm like, oh my God, what the fuck? All right. So it looks like they only filed a motion for a temporary injunction. Looks like that's all they filed. So my bad. Wait a second. 1 second here. Okay, sorry about that. So I thought that I'd read over Katie's response to the temporary injunction. So I'm going to go ahead and just get right to that. We have and I probably am going to turn the camera off for that bit because I have to wear my glasses to read it. And I look like shit without the filter, I think. And I especially look like shit with glasses on and without the filter. So that's my opinion. That's how I feel about it. I warned you all a long time ago. I am a bit vain, just a little bit. Okay, so let me check the chat though before I go do that. Holy shit. Hi, Mr. Black Wolf. Hey, Gracella. Hey, Reagan. What does it say? Oh, okay. Oh, thank you, but yeah. I like my filter. I'm sure that they'll get it. They'll fix the patch, whatever. It's like the third time I went down in the past 2 years, so I'm not too worried about it. But I did find that there's something called Snapchat camera for a Chrome extension. I downloaded that because the lens I like to use is also on Snapchat. But I can't get that to work on my computer for some reason. Like it recognizes my camera, and the streaming site recognizes the Snapchat camera, but not something just gets missed along the way because the screen just stays like gray and yellow and shit, nothing else. So I don't know. I'll have to look into what I'm doing wrong there to get it to work. But that's for another day. Not today. And someone moved my fan. God damn. Not happy. Not happy about that. Okay. Come on. Okay, that's good. Okay. What the? Did there? There we go. Oh, I accidentally hit the remote. Okay. I was like, what the hell? Someone's fucking with me because I look like shit. Now they're going to enlarge my face. Anyway, let me share screen. So what I'm reading here, what I'm going to be reading here is Katie Joy's response to their motion for a temporary injunction. So no, I'm just going to put that on the full screen. Here we go. That works. Okay. So it says here, defendants reply, memorandum of law, supporting motion to reconsider. That's what she filed. My bad. That's right. All right. You know what? We're going to read this first. So she did send or create a reply to the motion for a temporary injunction, and it's this letter here. But I didn't see the letter listed in any of the court filings there, but Balls has it up on her account. So, and I think Katie shared it on her Instagram. That's where Balls got it from. But here, though, she says, Dear Ms. Stavig, pursuant to Minnesota, whatever, civil procedures, 1103 and this letter serves as formal notice that unless plaintiffs withdraw their pending motion for a temporary injunction within 21 days, defendants will move for sanctions. The motion is sanctionable for multiple reasons. One, unconstitutional prior restraint. Plaintiffs asked the court to enjoin Ms. Paulson from making public statements about them. Such relief is a classic prior restraint, which the Supreme Court has repeatedly condemned as the essence of censorship. I'm not going through and reading all that shit, but yeah. So, and then there's another page to it, but I think it's just what, let's see. Okay, this court has already denied plaintiffs' first motion for a temporary injunction in 2023. Repackaging that failed request with no new facts or law is not zealous advocacy. It is wasteful. 2, procedural timing and selective complaints. The timing and scope of plaintiffs' request further reveal its lack of merit. Plaintiffs filed this extraordinary motion while defendant's motion for reconsideration of summary judgment is pending, compounding burden without advancing substance. Even more telling is what plaintiffs have not done. They have never sought a retraction or correction of the very July through August 2025 posts they now claim justify emergency relief. Their affidavit, what? Are you blaming them? Are you saying that it's their fault because they didn't correct you? Wow. Their affidavits do not even, I'm curious, has Katie ever reached out to 7M or Miranda or Robert Shin or whomever to ask for them to verify any of the things that she was going to report or any of the things that she was told? Has she ever contacted them or given them a chance to say anything on her platform? And if she had, do you think she would have actually aired it if it went against what she was saying? But it's the second one is whatever. That may be overstepping, but she never did. So now what? Now she's going to give them shit for not contacting her? You know? Okay. But she's a professional, y'all. Their affidavits do not even identify those posts. Having tolerated years of reporting without objection and having, until this motion, ignored the specific content they now target, plaintiffs cannot credibly claim imminent, irreparable harm. Urgency that materializes only when convenient for motion practice is not urgency at all. Lack of legal, oh my God, this reads like just is so gaslighty. Holy shit. Lack of legal and evidentiary basis. The affidavits submitted in support of the motion illustrate its hollowness. Each consists of little more than the assertion that, quote, no criminal charges have been made. That truism, while unsurprising, does not establish falsity, malice, or irreparable harm. It adds nothing to the constitutional analysis. Miranda and James Derrick further state they deleted their social media accounts due to professional backlash, but that harm is neither new nor tied to the July through August 2025 posts. It is simply a continuation of the reputational consequences plaintiffs have faced since they chose to bring and prolong this litigation. Harm that is cumulative, self-inflicted, and untethered to the content of the present motion cannot justify censorship. If this is the strongest evidence plaintiffs can muster in support of the most disfavored remedy in constitutional law, the motion speaks for itself. 4, improper purpose. This motion is not about preserving judicial process. Plaintiff's own memorandum confirms it is about silencing commentary on matters of public concern. Filing serial injunction motions to harass defendants to relitigate issues already rejected by this court. Didn't she also file a reconsideration? Okay, never mind. I'm sorry. And to suppress ongoing public debate is the very definition of an improper purpose under Rule 11b1. Conclusion. Plaintiff's motion is frivolous within the meaning of Rule 11. It recycles relief this court has already denied, rests on affidavits that add nothing of legal substance, and demands the most disfavored remedy in constitutional law without new facts or law to support it. Plaintiff's selective, belated focus on a few July through August 2025 posts only underscores the tactical nature of their request. Unless withdrawn within 21 days of service, defendants will move for sanctions, including attorney's fees incurred in responding. Okay, then. That's interesting. All right, so back to the filing here. Let me check chat real quick. And let me use that. Yeah, no, she didn't. Exactly, she didn't. Okay. So this is the defendant's reply. Memorandum of law supporting motion to reconsider. Introduction. Defendants submit this reply in further support of their motion to reconsider the court's June 23, 2025 order. Reconsideration is warranted here, not because defendants disagree with the court's reasoning, but because the order permits claims to proceed in ways foreclosed by binding First Amendment precedent. Plaintiffs' opposition does not meaningfully engage with the constitutional efforts set out in defendants' memorandum supporting reconsideration. Instead, it misunderstands the remit of Rule 115.11, misstates the governing law, and relies on rhetoric in place of authority. First, plaintiffs misunderstand the remit of this motion. Rule 115.11 permits reconsideration when a decision is, quote, palpably wrong. Defendants' supporting memorandum explained that reconsideration is proper here because the court's order deferred threshold constitutional questions to a jury, treated implications as actionable, and diluted the actual malice standard. Plaintiff's opposition does not address that remand. Second, plaintiffs misunderstand the law. Defendants' memorandum walked through controlling precedent. Milkovich, okay, I'm not going, a bunch of names there. Plaintiffs cite none of these cases. Instead, they rely on procedural authorities about new arguments and an unpublished decision, Finn, that had no precedential value. As already explained in defendant's memorandum filed August 15, 2025, the arguments at issue were raised in the summary judgment briefing and then clarified in light of the court's ruling. Third, plaintiffs argue in bad faith. Their opposition accuses defendants of, quote, grandstanding and, quote, lying, but never grapples with the constitutional standards already laid out in defendant's memorandum. Adjectives cannot substitute for authority. Hostility cannot substitute for analysis. The court should view these tactics for what they are, an effort to obscure the absence of controlling law. For these reasons, and as further developed below, the supposed errors identified by plaintiffs in defendants' memorandum supporting reconsideration remain unaddressed. Correction of the June 23, 2025 order is necessary to ensure that constitutional standards are properly applied at the stage. 2. Standard for reconsideration. Minnesota Rule of General Practice 11511 provides that motions for reconsideration, quote, shall be granted only upon a showing of compelling circumstances. The advisory committee comments further explain their reconsideration is appropriate where a decision is, quote, palpably wrong in some respect. Defendants' initial supporting memorandum set forth how the court's order misapplied controlling First Amendment precedent in ways that are dispositive of plaintiffs' claims. That is the very circumstance Rule 11511 contemplates. The Constitution simply does not permit errors of this kind to be left for a jury. Rule 11511 ensures they are corrected now. In their opposition argument, plaintiffs misstate this standard in two respects. First, they argue that a motion for reconsideration cannot present new arguments, but defendants have not introduced new facts or theories. The arguments before the court are the same defenses advanced in defendant's summary judgment briefing and clarified in the memorandum supporting reconsideration when the court's ruling crystallized the constitutional errors. The only refinement addressed defamation by implication, a theory elevated by the court's order itself. Identifying that constitutional flaw is not new argument. It is the very function of reconsideration. Second, plaintiffs rely on cases that do not control here. They cite American Bank v. Coding Specialties and State v. All Wine for the remarkable proposition that reconsideration cannot be used to submit new evidence. Again, defendants are not doing so. Plaintiffs also cite v. Walworth State Bank, an unpublished case with no precedential value and no relevance to First Amendment constitutional error. None of these authorities address the core principle at issue when it fails to apply binding precedent in opinion versus fact, actual malice, or boycott advocacy. The error is not discretionary. It is constitutional, and reconsideration is required. By reframing reconsideration as a procedural game, plaintiffs ignore the substance of the rule and the authorities that govern here. The court has the duty to correct constitutional missteps before trial. That duty is what defendants invoked their supporting memorandum, and plaintiffs' opposition offers nothing to the contrary. 3, plaintiffs' new argument claim is wrong. Plaintiffs' opposition repeatedly asserts that defendants are raising, quote, new arguments on reconsideration. The record shows otherwise. Each issue identified in defendant's motion was presented in defendant's summary judgment briefing and then further memorandum supporting reconsideration when the court's ruling crystallized the constitutional errors. A, opinion versus fact. Defendants argued in their summary judgment memorandum that terms such as, quote, cult and hashtags like trafficking were rhetorical hyperbole, and non-actionable opinion. Okay. The reply memorandum reiterated that plaintiffs had failed to distinguish fact from commentary, emphasizing the role of context. Context, end of sentence, sorry. Defendant's reconsideration memo expanded on this argument only because the court's order deferred the threshold legal question of opinion versus fact to a jury. That is not a new argument. It is the correction of a constitutional error. A, actual malice. Defendant's summary judgment briefing explained that plaintiffs had, quote, no evidence that Ms. Paulson subjectively entertained serious doubts as to the truth, citing Anderson v. Liberty Lobby and Minnesota cases adopting its standard. The reply memorandum reinforced this point. The reconsideration memo addressed the court's conclusion that plaintiffs' denials suffice to create a jury issue. The argument was not new. It became necessary once the order diluted the clear and convincing standard. B, tortious interference. Defendants argued at summary judgment that calls for boycott are constitutionally protected and that any interference was justified under the refusal to deal doctrine. Defendant's reconsideration memo cited NAACP v. Claiborne Hardware to reinforce this principle in light of the court's conclusion that justification was a jury issue. Again, not a new argument, but a response to the constitutional error revealed by the order. D, negligence per se. Defendants argued at summary judgment that Minnesota statutes was unconstitutional and could not support liability. The reconsideration memo simply reiterated that point in light of the court's contrary ruling. The only refinement was to address plaintiffs' reliance on implication as a theory of defamation. Defendants' reconsideration memo explained why implication alone cannot confer liability under Milkovich and Jadwin. That refinement was necessary only because the court's order treated implications as sufficient. Correcting that constitutional error falls squarely within Rule 11511. In short, plaintiff's opposition does not demonstrate that defendants raised new arguments. It demonstrates that only that plaintiffs have chosen not to engage with the record. The arguments were briefed, cited, and developed. The court's order revealed why correction was necessary. The only new material in this case is the rhetoric in plaintiff's opposition. A little shade there. 4, the court's gatekeeping duties are constitutional, not discretionary. Plaintiffs contend that most issues raised in defendant's motion should be left to a jury. That argument misunderstands the court's constitutional responsibilities. In defamation cases, the Supreme Court and Minnesota courts have imposed specific gatekeeping duties on the trial judge. These threshold determinations cannot be delegated to a jury. Wait, that's not what the judge did. The judge was saying it should be heard by a jury because a reasonable jury could like vote either way. She wasn't leaving it up. Oh my God. Well, she is in the sense that they are asking for a jury trial, but she's not leaving it up to a jury to decide whether it's okay. Whatever. Fucking ridiculous. All right, I'm sorry. I'm going to try and do this without commentary, but sometimes something slips out. A, public figure status. Whether a plaintiff is a public official or public figure is a question of law for the court. Rosenblatt v. Baer, whatever. It is for the trial judge in the first instance to determine. Okay. Here, plaintiffs, media influencers, entertainment managers, and the leader of a church at the center of public allegations make their status a threshold legal question that must be resolved by the court. B, facts versus opinion. Whether the challenged statements are actionable statements of fact or protected opinion is likewise a legal question for the court. Rhetorical hyperbole and figurative language, including hashtags and commentary, cannot be submitted to a jury as though they were provable factual assertions. Wait, so all she does is rhetorical hyperbole and figurative language through hashtags and commentary. She's no longer an investigative journalist. So therefore, the privilege or whatever rule for journalists in Minnesota would not apply to her then, right? I mean, that's how I read it. I don't know. I'm not a lawyer though. I'm not. C, sufficiency of evidence and actual malice. Finally, the court must determine whether plaintiffs have presented evidence from which a jury could reasonably find actual malice by clear and convincing proof. This is not fact-finding. It is a constitutional safeguard to ensure weak or conclusory allegations do not proceed to trial. That's what the judge explained. Together, these gatekeeping functions ensure that defamation claims proceed only when constitutional thresholds are satisfied. Plaintiff's opposition seeks to collapse those duties into jury questions. That is not the law. The issues raised in defendant's motion fall squarely within the court's non-discretionary responsibilities. The court has the duty and the authority to correct these errors now. Respectfully, defendants ask that it do so. 4. Opinion versus fact is a threshold question of law. The court's order concluded that a jury could treat Ms. Paulson's commentary and hashtags as actionable factual assertions. Defendant's reconsideration memorandum explained why there was a constitutional error. Whether a statement is fact or opinion is a threshold question of law, not an issue to be deferred to the jury. Well, okay, maybe it's just me, but I interpreted what the judge had said is that, like, say any post mentioned, like this post here, the way it's constructed, the way it's written, it could come across as a factual statement or an opinionated statement to a jury. The judge wasn't saying a jury can determine whether or not that's true or false. She's saying that a jury might not be able to tell if what they're reading is alleged to be an opinion or a fact. It could be either one. It's not clear. So if it's not clear to be opinion, then it could very well be taken as fact. The judge wasn't saying that the jury will determine whether or not what that post said was factual. Just, okay. It's like, I swear, I don't know if it's just me, but it seems like as I get into my older age that people just fucking don't know how understand the meaning of words and sentences anymore. It's crazy. Okay. Defendants raised this issue in their summary judgment briefing. They argued that references to, quote, cult and hashtags such as trafficking were rhetorical shorthand, not provable factual claims. Well, sure. Don't you all remember that class you took in like 7th grade English? It was called rhetorical shorthand. I mean, because we're all familiar with this and what the fuck that means, right? Oh my God. Okay. The reply memorandum reiterated that plaintiffs had failed to distinguish between protected commentary and actionable statements. Plaintiffs' opposition ignores those citations and instead repeats that the issue is, quote, factual. That misstates the law. Minnesota courts have long recognized that rhetorical hyperbole and figurative language are not actionable because they cannot be proven true or false. Social media hashtags, by their very nature, are not carefully drafted factual assertions. They function as shorthand to frame a subject of discussion. To treat hashtag trafficking as equivalent to an express criminal accusation is to conflate commentary with fact. The precise what? Is she fucking for real? Okay, if it was just like one trafficking thing, then okay, but there were so many of them, and it wasn't just the one hashtag. Okay, you can't judge each hashtag by itself when there's 50 of them on a post. You kind of take what all 50 of them present to you is that's the picture, that's the image that the author is trying to convey to you. And one hashtag isn't going to give that image. It's going to be all of them. And God knows that she put all the fucking hashtags on them. Plaintiffs cite no controlling authority to the contrary. They rely instead on procedural cases about, quote, new arguments and ignore the constitutional gatekeeping duty. By doing so, they seek to shift the court's responsibility onto a jury. That is not the law. Correcting the error in the June 23, 2025 order does not expand the issues before the court. It reinforces what defendants already argued at summary judgment and clarified in the reconsideration memorandum. The threshold determination of opinion versus fact is for the court. Plaintiffs' refusal to engage that principle underscores why reconsideration is necessary. 5. Actual malice is the only standard, and plaintiffs have no evidence of it. The court's order treated plaintiffs' denials of defendants' reporting as sufficient to create a triable issue of actual malice. That conclusion was constitutional error. A. Public figure status is a legal question for the court. The Supreme Court has made clear that public figure status is a threshold determination for the court, not a jury. Minnesota courts have followed the same rule. Here, the record leaves no doubt. Okay. First, it would have been impossible to report on the Wilking family's public allegations without also reporting on Robert Shin, Shekinah Church, and 7M Films. By their own conduct, these plaintiffs were at the center of an ongoing public controversy. Next, the Derricks are nationally known social media influencers with millions of followers, monetizing their image through brand partnerships. They voluntarily built their careers on publicity. Finally, Robert Shin and 7M Films promoted themselves publicly as a religious and management enterprise, negotiating contracts and courting brand deals. Even plaintiff's own briefing concedes that, quote, if the plaintiff alleging defamation is a public figure, a heightened standard applies, and that Paulson's conduct would meet their burden, quote, as if they were public figures. Plaintiffs cannot acknowledge the standard while disclaiming the status. Once they are public or limited purpose public figures, and they plainly are, the only permissible standard is actual malice. B. Actual malice requires proof of subjective knowledge or serious doubt. The actual malice standard is narrow and demanding. Liability may be imposed only if a plaintiff proves that the defendant published a statement, quote, with knowledge that it was false or with reckless disregard of whether it was false or not. Common law malice, ill will, hostility, or financial motive is not sufficient, nor is mere failure to investigate. Defendants argued this at summary judgment and explained it again in their reconsideration memorandum. Plaintiff's opposition does not engage with this standard. Instead, it points to Ms. Paulson's alleged financial motive and her desire to see Mr. Shin, quote, held legally accountable. That is not evidence of actual malice. At most, it is evidence of common law malice, which the Constitution forbids as a basis for liability. C. Plaintiffs presented no evidence of actual malice. Under Anderson v. Liberty Lobby, Incorporated, the clear and convincing burden applies at summary judgment. The court must determine whether plaintiffs have presented evidence from which a reasonable jury could find actual malice by clear and convincing proof. Plaintiffs offered none. Their depositions consist of denials that defendants' reporting was not true. But a plaintiff's disagreement with reporting is not evidence of the defendant's subjective state of mind. There is no document, no admission, no testimony showing that Ms. Paulson believed her reporting was false or had serious doubts about it, nor is there evidence contrary to her reporting. There is evidence contrary. Okay. For argument's sake, let's say that she did believe her reporting was true or she didn't have serious doubts about it. Well, then there's still negligence in the sense that she had a reckless disregard for the truth. But why is Siri talking to me? She had a reckless disregard for the truth. Like she didn't do her proper due diligence in verifying things. Had she done that, then she would not have had serious doubts. Or she would have, if she had done that, then she would have had serious doubts. She would have suspected or considered that her reporting might not be factual or actual. That's my opinion anyway. See, an actual investigative journalist would have learned that and would have known how to do that and known to do that. Okay. By treating bare denials as sufficient, the court inadvertently reduced the constitutional standard to a credibility contest. That is the very error the First Amendment forbids. 6, negligence per se under Minnesota statute 609-765 cannot support liability. The court's order allowed plaintiffs' negligence per se claim to proceed under Minnesota statute 609-765, Minnesota's criminal defamation statute. Defendant's reconsideration memorandum explained why this was constitutional error. Permitting 609-765 to operate as negligence per se would allow plaintiffs to recover without satisfying actual malice. That end run around Sullivan is constitutionally impermissible. A, even if kind of long. Okay, I want to read this. Just whatever, this site, whatever. I can't think of the word now. Even if common law malice, such as ill will, hostility, or financial gain, were oh wait, didn't I read this already? Plaintiffs have presented no competent evidence of it. Ms. Paulson had no personal connection to Mr. Shin. Her reporting was based on publicly circulating allegations, and her conclusion that he behaved like a, quote, cult leader reflects her interpretation, not malice. Allegations that she earned money from her reporting or wanted plaintiffs, quote, held accountable, are neither legally sufficient nor factually supported. Indeed, well-settled law confirms that a publisher's profit motive without more cannot establish actual malice. Interesting. Okay. A, the statute cannot supply a civil standard. Negligence per se requires a valid statute that defines a, let me start over. Negligence per se requires a valid statute that defines a duty. Minnesota Stat 609-765 does not qualify. Criminal defamation statutes have long been subject to strict constitutional limits, and Minnesota courts have recognized that the 609-765 is enforceable only in narrow circumstances, if at all. To use it as the basis for civil liability would compound those constitutional infirmities. Yeah, infirmities, whatever. B, the First Amendment forbids it. The Supreme Court has made clear that criminal defamation laws cannot be applied in ways that dilute constitutional protections. Here, plaintiffs seek to repurpose 609-765 as a negligence per se standard. They would permit liability without proof of actual malice. The very result New York Times v. Sullivan and its progeny forbid. C, plaintiffs cite no authority supporting their theory. Plaintiffs' opposition does not identify any Minnesota or federal decision holding that 609-765 may be used as the foundation for negligence per se. The absence of authority is telling. Negligence per se is a narrow doctrine. It cannot be used to bypass First Amendment limits on defamation claims. 7, plaintiffs' September 5th letter confirms noncompliance and is no basis for sanctions. Plaintiffs' September 5th, 2025 letter underscores the discovery concerns defendants have raised throughout this litigation. For more than 18 months, plaintiffs ignored this court's order requiring the disclosure of financial information. Then, on the very day their response to the instant motion was due, plaintiffs finally produced much of the information defendants had been seeking. So what are you bitching about, boo? Their transmittal letter, however, accused defendants of discovery misconduct and threatened sanctions. That position speaks for itself. Because plaintiffs' production occurred long after the close of discovery, defendants may still seek sanctions and or the opportunity to reopen discovery in order to depose plaintiffs, employees responsible for bookkeeping and financial records, and plaintiffs' tax accountant and his files. What are you doing? Wait a minute, I gotta put this on mute for a second. Okay, sorry about that. As that additional motion may be necessary, the court need not address sanctions in the context of this motion. For present purposes, plaintiffs' accusations provide no basis to deny reconsideration. If anything, they confirm a pattern of obstruction that reinforces why constitutional thresholds must be applied rigorously at this stage. 8, conclusion. The court has the duty and the authority to correct these errors now. Respectfully, defendants ask that it do so. Plaintiffs' opposition does not meaningfully address the constitutional errors identified in defendants' motion supporting reconsideration. or defendant's memorandum supporting reconsideration. Instead, it relies on rhetoric and accusations while avoiding the controlling precedent that governs this case. The court's gatekeeping duties are clear: to determine as a matter of law whether plaintiffs are public figures, whether the challenged statements are fact or opinion, and whether plaintiffs have produced clear and convincing evidence of actual malice. On each point, plaintiffs have failed. They are public or limited purpose public figures. Their status is a threshold legal question, not a jury issue. The challenge statements are rhetorical hyperbole and opinion, not provable factual assertions. And plaintiffs have presented no evidence, let alone clear and convincing evidence, that Ms. Paulson knew her reporting was false or that she harbored serious doubts about it. Plaintiffs' remaining claims fare no better. Tortious interference cannot be based on constitutionally protected advocacy, and negligence per se cannot be founded on a criminal defamation statute that the First Amendment does not permit to be used as a civil duty of care. In short, the only new material here is the rhetoric of plaintiffs' opposition. The controlling law has not changed. What has become clear is the court's order permitted claims to proceed on grounds foreclosed by Sullivan, Milkovich, Anderson, Rosenblatt, NAACP, and their Minnesota counterparts. Correction is not optional. It is constitutionally required. For these reasons, and for those stated in defendants' memorandum supporting reconsideration, defendants respectfully request that the court grant their motion, reconsider its June 23, 2025 order, and enter summary judgment in defendants' favor on all claims. Okay, acknowledgement. Yeah, she signed it. Okay. Wow. Holy shit. That was something. All right, there we go. Oh, that's right. Sorry. I gotta fix this. Sorry. Why is it not doing that? Okay, there we go. Kinda. All right. Where's the other one though? I don't want that one. What happened to all of my things? I don't understand. New layout. Huh, that's so weird. I don't know what's going on with my scenes here, but apparently they're not really working. Speaker view, that's what I want. Okay, there we go. Sorry. I haven't used StreamYards in a while. They like all changed their shit and everything, so it's been a little bit getting used to. So let's see here. Let me check chat. Hi, Mr. Black Wolf. Hi, Taboo Topics. What's up? Yeah, not to mention using Miranda's picture over and over, whether or not the story was about her. You're right, Michelle. Hi, Michelle. Hi, Teresa. This is the recent filing. Yes. So, here, wait. Let me get back to the page I got it from. All right, I'm gonna have to do the search again. Wait a second. Okay. All right, so this is what I want. So let me share the screen here quick. So when I search for her name in the Minnesota court records, their MCRL, this is her case number or case information with 7M Films. And you scroll down here and you see like all the recent filings, all the case events rather listed. So what I just read now was from what was filed on 9/18. I did the 12 pages here. That's what I just read. So this is the memorandum from Katie's side. And then there's the affidavit, whatever. And then there's a notice of hearing. There's a hearing coming up on, I forget what the date was. Hang on. The hearing is on October 17th. So, and for now, the judge has taken shit under advisement. And I I mentioned Southern Mutton's video earlier in the stream. Now, Southern Mutton went over the 917 filings, and that was from 7M side. So, and she did a fantastic job about it. There's nothing I could add to it really. So I'm not even going to bother trying. I'm just, you know, I'm going to go grab a link to that video, I think. So, because I want to recommend people go watch it. Let me see here. It's just going to take a second. You know, and actually, I know that I'm holding stream up here right now to do this real quick, but my computer is moving so much faster, man. I fucking love this. I deleted so much shit from it today. And it's like, it's so fast. I can't believe it. Love it. Love it. All right. See, already I'm on her page. I'm already grabbing the link I need. This is crazy. What's the date? Okay, so it's this one. Share, copy. Okay. I watched them all. I can't tell which one. I think it's this one. Yeah, it's not the one from 13 days ago. So here you go. Here's the link for Southern Mutton's video. Go check it out. Hi, Claudia. Hi, Christine. Member for 8 months. Yay. Thank you. Thank you for your support. Glad to have you. So yeah, so this is the recent report. So yeah, there's that. I also want to read a couple of her posts there. Let me X these out. Get over to Instagram. Am I logged in? I think I'm logged in. Yes, I think I am. Awesome. Yeah, I listened to I'm gonna do a video on this soon. I'm collecting my sources and shit for it, but the whole announcement from Trump today about acetaminophen and autism and shit, I was out. I heard about it earlier today, but I didn't hear his press briefing or whatever until I was walking the dog tonight, like about an hour before I started streaming. And I'm walking down the street and I'm listening to him try to pronounce acetaminophen, and I started laughing my ass off. Like there were people outside and shit on the street. I was walking down and they were just looking at me like I was crazy. I'm like, oh my God, that's so bizarre. Like what? Like, I don't know. Okay, I'm gonna get into that in another video. Anyway, I want to read this for now. Let me get over to that screen. Okay, so here, like this is, okay. Anyone who's actually advocating and fighting for someone, they don't need to announce this to the public so often and to present themselves in this like glorious, noble, like, humble light. Like I'm doing this fantastic thing because it's the right thing to do. Like anyone who's genuinely doing that because they care about people, they don't need that kind of adoration as a result. The people who need that kind of adoration are the ones doing it solely for that adoration, are the narcissists, in my opinion. I'm not a psychologist, but I doubt I'm that far off. So anyway, here she says, we won't stop fighting for you, Miranda. 1,095 days. And still today, September 23rd, 2025, we are here fighting for Miranda Derrick. In a recent court filing, Miranda Derrick's attorneys filed an affidavit that accused me of aggressively attacking her and causing her to delete her social media. A rambling motion for temporary injunction was filed against me by Robert Shin, Miranda, and James Derrick. The document, wait a minute, let me check something. Sorry, I don't mean to interrupt. I just want to make sure everything's coming through. Okay. The documents paints my reporting as though I'm committing a crime by publicly reporting on a federal raid that was highly publicized and included multiple federal agencies. Federal agents released a statement confirming a multi-agency federal investigation into Robert Shin and his associates related to trafficking, people trafficking, mail fraud, tax evasion, and more. Robert's attorneys filed a motion to stay discovery in California and told the court that Robert and his associates may incriminate themselves if they were forced to sit for depositions. And, you know, when I first heard this explained and shit, I thought, well, that makes sense, right? Because I don't know how to put this. They have to be honest and tell the truth or whatever, but it can be misconstrued and then it can be used and applied differently or taken out of context and used in a more manipulative way. You know, then when you're explaining something to someone for one reason, it may come across, you may have more or different information to give or to admit than explaining something to someone else for a different reason. You know what I mean? Context matters. So that makes sense to me. I don't know. It may incriminate themselves if they were forced to sit for depositions. Attorney Daniel Gutenplan told the judge the following. 5 search warrants were executed on 5 properties. The search warrants confiscated all electronics, computers, phones, and documents. Days later, a U.S. attorney subpoenaed Robert and others to appear before a grand jury. There is reason to believe that Robert and associates could be indicted imminently. All of this is in court filings. Daniel Gutenplan signed declarations under the penalty of perjury. In Minnesota court, Robert's attorneys falsely accused me of claiming Robert had been arrested. She said that. I remember hearing her say on her channel that he, okay, faked outrage over my coverage of the raid and blamed me for Miranda and James deleting their social media. And now I need your help. We are desperate for more exposure. We need, what? Yo, girl, that's what got you in trouble in the first place. Like, you wanting more exposure isn't going to help you. Why would you? Oh my God. We need to keep up the pressure because we are worried about Miranda and James. You are not. That's it. Put more pressure. Like, if what she's saying about Miranda and James were true, if they weren't in this cult, then, and they're being put into the public spotlight because of these raids, then her asking for even more pressure and more coverage is going to only put them more at risk. This is what I mean. We won't stop fighting for you, Miranda. More like, we won't stop fighting you, Miranda. That's how that should read. My attorneys will be filing a motion for Rule 11 sanctions, a motion for deleting evidence, and today are sending a safe harbor letter to demand they withdraw their motion and lawsuit or face Rule 11 sanctions and be on the hook for not only attorney's fees, but for damages that they have caused me. Because that's how you fight for Miranda. You worry about your fucking damages. I'm not going to stop fighting for Miranda and my damages. And I know her family won't stop until she's safe and home. That's the craziest shit I think I ever read. Like, oh my God. Like, how were you so delusional? Yeah. What have Miranda's parents said recently? Are they still trying to contact her? Just another bullying tactic. It's funny, just another bullying tactic. But the other side hasn't posted a fucking thing. They haven't put anything up on any social media accounts regarding Katie Joy or this lawsuit. They haven't spoken to any media. They haven't gone on News Nation and done any interviews or whatever. They've said nothing. But they're the bullies? They make that make sense. Anyway. All right, so then there's this one. Massive update. This is from a day ago. Massive update. The federal investigation into alleged cult leader Robert Shin has taken a shocking turn. After the FBI raid, Shin and his followers are now trying to frame me. This feel like is, well, oh my God, I can't with this shit. I thought she was using AI for her shit. Why are these errors here? This feel like is intimidation and retaliation, and I will not stay silent. Video dropping soon. Stay tuned. But I'm here fighting for Miranda, y'all. Oh, Ghost Circuit, you're catching on. Damn, girl. It seems like everyone you report on tries to come after you. Do they, though? Do they really? You turned off and deleted all the comments on the macaroons. Why? You are as fake as everyone else. Unfollow. Yeah, why don't we read some of those too while we're at it? I'm not here to argue any shit with the macaroons, whatever. I don't really give a shit. And you know what? This is the stupidest thing I think I've ever heard. Macaroons to offer scientific evidence to U.S. court to prove Brigitte is a woman, lawyer says. Why? What does it matter? What the fuck does it matter if she's a woman or not? Who can? Why? Why? Okay. The First Lady of France is preparing to provide scientific evidence that she is a woman after Candace Owens claimed she was born a man. Why is she doing anything because of what Candace Owens said? Like, for real. Okay. I watched the series by Owens and then did my own research. Here we go. Almost all of the points she makes are easily, verifiably false. Why is Katie even given this any fucking air? Like, seriously. Owens claimed Brigitte is actually her brother, but her brother is alive and has been interviewed. Brigitte had 3 children with her first husband. They were not adopted and were born during her first marriage. Owens also said there are no photos of Brigitte for 30 years, which is not true. Brigitte's daughter, I don't know how to pronounce that, Tiffany Osry, has spoken publicly to defend her mother and said, I worry about the level of society when I hear what is circulating on social networks about my mother being a man. Brigitte's brother has also spoken to multiple European publications about the rumors. Owens said her daughters had never spoken out, but they have. She relied on her audience accepting her words as fact. Imagine that. So Katie realizes and agrees that that's wrong to do? That would be a new development. Okay, then. A simple DNA test will verify that Brigitte has XX chromosomes. The Macrons have already provided extensive evidence to Owens before filing their lawsuit. Because the facts were available and clear, showing malice will not be difficult. That opens the door for liability. The real controversy surrounding Brigitte Macron is not her gender. It is that she was a teacher when she met Emmanuel. He was 14 years at the time, and by 15, they were in a relationship, which is the age of consent in France. That's fucked up. The age gap and power imbalance is the real issue. In the United States, Brigitte would be a sex offender, but she lives in France. Wait, who's Emmanuel? Is that the president? I don't think. No, wait. When she met Emmanuel. Oh, yeah. No, wait. That's Emmanuel. Who the fuck is Emmanuel? Is that her ex-husband or is that the fucking president? Because I'm reading this and she has an ex-husband because she has 3 kids with him, right? And now she's with the president. So it can't be the president. That wouldn't make sense. Despite claims that Brigitte is a PDF file, attraction to a 15-year-old is not the same as attraction to a I don't even know how to pronounce that. I don't think it matters. If philia is an attraction to 15 to 19-year-olds and is not regarded as a psychological condition. Like, it's not regarded as a psychological. Well, very small argument to maybe not to the extent of that, but I don't think it's really that much better. It should not be definitively discussed. They kind of should be looped in together, I think. Candace why does she even care about that? Why is she caring about making that distinction right here, about clarifying this? Why does she care that that this woman is not seen as the PDF file, but as this other word, and it's not regarded as a psychological condition like PDF files, you know? Why does she care? Oh. Huh. So Katie's like almost 50, right? Would that be considered like an old lady? Maybe she's just gearing up excuses or, fucking, I don't know, pardons or whatever for her harassment of young people that's up and coming. I don't know. For those who don't know what I'm talking about, Katie once said on video that she can't wait to become like one of the old ladies so she can sexually harass all the young boys. That's literally what she said. That's not taken out of context or anything. Anyway, Candace has had months to back down, and her stubbornness has put her in this situation. Free speech is one thing, but ignoring evidence is not only irresponsible, it's defamatory. The fact that Brigitte even has to do this is so disturbing. That I agree with. I mean, no, about the whole proving she's not a man thing. That's fucking disturbing. That is. I don't really care about Justin Baldoni. Huh. Okay. This is true, though. There are no links between using Tylenol and child developing autism. I'm going to be making a video about that soon, though, because this was covered. This is one of the reemerging arguments from the pseudoscience side. It's not even strictly reserved for anti-vaxxers. It's like the entirety of the pseudoscience community or whatever. They all make this argument. And it's just, they recycle the same arguments over and over and over again. Like, for example, I do want to discuss this just a little bit. Not the Tylenol thing, something else. There's a video that I watched, or it's a short or whatever, on YouTube earlier. Let me get to it. It was from Debunk the Funk. That is a channel I follow here on YouTube. I met him during my advocacy days for vaccines, and he's very smart and he's entertaining to listen to, and he breaks things down so that people can just understand it, Anyway, so let me pull this up here real quick. I'll put a link to this in the chat in the description momentarily. Let me share this. Okay, so this is from, damn it. Oh, stop it. Okay, Debunk the Funk with Dr. Wilson. That's the name of the channel, okay? And I want to just get, what's an upload date on this? 14 hours ago. So it's a newer one. Educating anti-vaxxers on mercury and vaccines. But I just want to play this. You can't really hear much of the argument because they just keep talking over him and shit. But it's a few other things that they bring up is why I wanted to show this.
Mercury in vaccines? There's no mercury currently in childhood
vaccines. But why'd they take it out?
So when they took it out, did autism
quite a long
increase?
time ago?
Why'd they take it out?
Because of the public fervor.
Yes.
They had never been demonstrated to be harmful at all. They took it out because of public fervor. But the point is 2001. And when they took it out, did autism rates decline or did they go up?
It's not just mercury.
So it's not thimerosal.
So
check thimerosal
off.
So
it says many of the adjuvants.
You said
so which one?
Polysorbate 80.
Which one?
Aluminum. Hang on. So you said
any
of
Polysorbate 80. Now, this is something I can actually talk about a little bit. This is brought up because of the vitamin K shot. This is one of the ingredients listed in the vitamin K shot that has been a continuous argument, or a reoccurring argument, rather, for mostly anti-vaxxers, but all pseudoscience people, really, in general. And polysorbate 80 it's naturally forming. First of all, it's not some chemical or whatever. It's like made in a lab shit that they're thinking, that they try to argue. It comes from naturally forming sources. Okay. And it's an emulsifier. That's it. It's just like, have you ever bought okay, so if you make salad dressing at home with like oil and vinegar, you know how it doesn't mix well, but yet if you buy it in a store, it still separates, but it mixes a lot better when you buy it in a store. And that's because they use something like an emulsifier in it that just helps shit blend together better so that they don't separate, That's all it is. And they're bitching and talking about this like it's some detrimental thing that's going to kill people. It's crazy. Anyway, we'll talk about that more, though, in the video I'm making. But let me get on over here. Oh, wait. First of all, let me grab a link to his page. All right. So this is Debunk the Funk with Dr. Wilson. There you go. Oh, I put a link up to his shorts. My bad. Whatever. I'll bring it to his page. Whatever. Oh, Grace, I'm so sorry your sister passed a couple years ago. And my mom 30 years ago also seems like yesterday. I'm sorry. Oh, the dove is Tammy Sue, the dove is to honor your late husband. Aw, that's nice. And it sucks losing people. I'm sorry for your loss, Tammy Sue. She participated in a whole documentary and was so proud. No, she's done nothing. Yep. Okay. All right. So, and then before I sign off, I want to go over here real quick because I just wanted to call a little bit of attention to a couple of posts I made on Twitter because, well, you know, I feel like I've dealt with for the past at least about almost 2 years. I've dealt with a lot of bullshits and misinformation and a lot of very odd and uncomfortable attention from a couple of YouTube content creators. Now, don't get me wrong. I love being relevant and I'm not going to bitch about that. I'm not like, whatever, talk about me. They have every right to talk about me. And I'm, you know, regardless of how fucking disturbing it is, hey, at least I'm being talked about, you know, glass half full kind of person, I guess, whatever. I'm still going to enjoy or whatever, or just make a point to make it very known when they can be proven wrong. And that's what I'm going to share with y'all here. That's all. Because I'm petty like that. But wait a minute, I want to read these first. This is from Balls about Katie's clarification between PDF files. Someone else wrote, I just want to point out the obvious. I think it's funny the timing of this is coming out, given Candace's current events and finding the true assassin and who's all behind it. A lot of people are swaying in her favor, opening up people's eyes to how involved. Okay, I'm not reading all that shit. Listen, I think Palestinian people have every right to an existence and a life on the land that they're in, but so does Israel. The whole thing is just ridiculous. Whatever. Katie says, she hasn't found the true assassin. She's lying to you. Please, come on, do some actual research on Candace. She's been doing this for 10 years online. Duh. She's been exposed so many times for being a fraud and lying. Why are you so hell-bent on calling her out without a crystal ball? You smell of desperation. Katie says, PDF files are attracted. Okay, I'm not going into that discussion again. Y'all can read that. Someone says, I'm stunned by your comments and stand on this. Unfollow. Katie says, I'm explaining scientifically what a PDF file is, and I never said dating a 15-year-old was right. In France, it's not illegal. I said that over and over. Nice cherry picking. But you don't say it over and over again. See, if she had said, listen, I agree with you. This is just fucking twisted. I'm not agreeing with any of it. The thing is that their laws are different than our laws, and this is why it's permitted there, and why, you know, it would not be, it would be treated much differently here. That's why it's treated the way it's treated over there. But hey, I agree with you. That's what that would sound like. But she's not. She's not even emphasizing any of their concerns or their complaints or their whatever. She's dismissing them to highlight hers. That doesn't come across as, hey, you're cherry picking, because you didn't give them any other different kinds of cherries, but that one kind of cherry. So they're picking the kind of cherry you put out there. So you kind of did that yourself, I think. I know I can't really come up with a good cherry analogy there. Not a PDF file. Are you on the same stuff as Candace? Just because Owens may be wrong doesn't make your theory is correct. Call it like it is. Well, APF is okay. I'm not going into that definition again. You get it. I know, but we don't know what happened and how it started. And the fact he was a minor does not mean it was a grooming behavior. Oh my God. We need some elements to the dynamic to confirm that. And the quote victim, if so, is still in a relationship with her. So that will never happen. Oh, maybe Emmanuel is the president. Okay, I don't know. Wow. Well, I mean, obviously, I don't know. I'm not getting into that whole discussion. I know you all want her to be painted as evil, but people are more than their age and connections, and real feelings happens without rules sometimes. If you want to worry with teenagers, that's far worse to worry. There's far worse to worry in the world than a relationship that exists to this day and resulted in marriage of years. What in the world did I just read? Children cannot consent to a relationship with an adult. An adult knows they are preying on a child who absolutely does not have the capacity to realize the gravity of the situation they're in. Please seek help. Katie wants to pipe in there and say, well, in France, a 15-year-old is not a child. Oh, wait a second. Hold on a second. Okay, so moving on. Okay, that's the end of that post. Let's see here. Yeah, wait a minute. Okay, sorry about that. Yeah, see, now here's what I want to, here's my opinion on that whole thing. With the whole Robert Shin being raided or whatever. See, we don't know exactly why he was. Like, I almost wonder if them doing so was like was their last necessary action to rule other people out before they zero in on the real culprit. I wonder. But that's just me. My post. Oh, wait, that's right. I'm on replies. I'm not even on my post. There we go. So I wanted to share this here. Because like I said, I went through my computer. I deleted a ton of shit. That's why my computer's running so much better now. And I got a whole bunch of stuff all ready and organized and shit for court. And I'm almost done. I'm surprised, actually. But here, though, I found this little, I found this video, actually. And it says, anyone else remember that anyone else remember that time that Goblin Q Chash backed out of a simple discussion on fucking Unirock's channel? I do. But you know who didn't do that? Me. It's not a debate if you don't leave your echo chamber and show up. So let's play it quick.
Isn't working for her.
Well, then, does she want to join the Discord server, I guess?
What's
she can
up?
come into my Discord server. Did she say this to you? In the DM?
No. She tweeted it out. Yeah.
Oh, come on.
I don't know. What's up with my screen? Why does it look like that? Okay.
just put them in general. Yeah.
Why didn't she use DM so we can just invite her to my server? Come on, Chess. You're not getting out of this. You're not going to make an excuse and run on. You can either just not come talk, or you can. You don't have to play these games. We aren't mean. We're not evil. We're not nasty. We don't bite. Well, I bite you because
Okay. All right. Hi. So I'm going to check the chat here real quick. Actually, I'm going to turn my camera back off because I can't read without my glasses tonight. So, all right. Oh, you don't have to thank me for not getting mad, Priscilla. Dude, the chat's you guys. That's your domain. You guys talk about whatever the fuck you want there. That's you. That's where you guys are, you know, and whatever, coming together. Huh. Awesome. Thank you guys for making the chat is what it is. Like, seriously, you all just, you're lovely people. You're funny, you're snarky, you know, and no one in here ever really says anything out of line. You know, like, you're not cruel, I guess is the word I'm really looking for. Sure, you're human, but you're not cruel. You know what I mean? And that's what matters, I think. So thank you for making it what it is. But all right, guys, I'm going to get going, and I'm going to work on that video, and hopefully I'll have it out in a couple days. But for now, I'm going to go to bed. Oh, sorry. I'm yawning. Okay. So, all right, guys. Good night. Thanks for being here. I'll see you later.